to Trade Commissioner Noah Phillips. President Donald Trump nominated Noah Phillips to be the commissioner at the Federal Trade Commission in 2018 when he was Senate confirmed unanimously on April 26th. Before he worked as an FTC commissioner, Phillips served as the chief counsel to the U.S. Senate John Cornyn, Republican from Texas, on the Senate Judiciary Committee. From 2011 to 2018, he advised Senator Cornyn on legal and policy matters, including antitrust, competition law, consumer privacy, fraud, and intellectual property. Prior to his Senate service, Phillips worked as a litigator at these law firms, Cravath, Swain, Moore, LLP, and then you were at Steptoe & Johnson, very familiar with them, and you began your career at Wasserstein Perella, do I have that one right? And Company as an investment banker in New York. He received his AB from Dartmouth College and his JD from Stanford Law School. So we love having you here today, and everything you've worked on, I'm very excited to talk about. But one housekeeping note, we will be taking questions on Twitter at #AskAEITech, as well as for the guests in the room. So thank you for joining us today. I really appreciate this.
Shane, thanks for having me. It's great to be here with you and at AEI.
You have been very busy over at the FTC. I was saying I kind of felt like we had a general sense of how things were supposed to work over there, and then there's just been a lot of ruckus and some things going on. So let's just start with one of my premises for the work I do in tech policy. I always like to say we should regulate and legislate towards an outcome, not legislate or regulate the technology, because technology needs a runway of innovation to be able to change and evolve. And I mean, I started with dial-up and AOL, and look where we are now. So I'm very concerned about the changes we're seeing and a lot of things. Let's start with the merger and acquisition guidelines. What's going on with that?
Sure, and I probably should preface, I certainly should preface what I'm about to say with the caveat that this is just my view and not necessarily what you might hear if you had asked my colleagues or the position of the commission as a whole. So, better part of a year ago, a little bit less, we put out a document with the Department of Justice Antitrust Division, which is our sister agency in enforcing the antitrust laws, in advance of doing new merger guidelines. And we're currently in the process of looking at the incoming and trying to decide in which direction we should go. I think there's always room for reevaluation and renewal when it comes to guidance that the government puts out. The 2010 guidelines, which was the last time we really redid how we think about mergers and their impact on competition, have been tremendously successful. They've been very little litigated over by parties, that is, people mostly agree with the framework they laid out, and they've been adopted by courts in evaluating mergers. And I think they lay out some really great rules, great guidance that helps not only the government in doing its job in sussing out what we ought to block and what we should let go, but also to businesses on what's okay when they do their planning. One of the things that we have done in the last year, especially at FTC, that has raised some concern with me is that we've been removing a lot of guidance from the market and not reintroducing anything to fill its place. So that was true with vertical mergers. We haven't gotten rid of the horizontal merger guidelines, but we'll see how we redo it. It's true with the scope of Section 5. What can we hold liable under the antitrust laws? On and on and on. Always good to look at things, see where we're wrong, see if the evidence and history and experience warrant a change in what we're doing. What I get a little bit concerned about, if you look at the document that we put out on the guidelines, is that we might deviate from law, that we might deviate from economic learning, that we might seek to prosecute sort of a vision of the world that, in my view, isn't consistent with our statutory instruction, which is to protect competition. There's a lot of ideas out there about what antitrust ought to mean. Some people use a phrase called anti-monopoly. And sometimes what they're talking about sounds a lot like competition to me. But too often, the way people talk about what they want to see antitrust accomplish, and they're very vague to some extent, sounds a lot less like competition and a lot more like a heavily government-regulated economy. And that's not the outcome that I want, in particular because I don't think it's the outcome that is going to benefit consumers most.
So a lot of the discussion around the FTC has come in parallel to legislation on both the House and the Senate side talking about antitrust and competition changes. And one of them is putting a threshold. And it's only on very specific companies, or the way it's designed, it sounds like it's for very specific companies. And for somebody who spent a lot of time in Silicon Valley, and I just finished a great book called The Founders that's about the founding of PayPal by Jimmy Soni. And these are two companies that didn't actually like each other, and they were going after different things. One was mobile banking, and one was trying to figure out kind of payments on a device. But it was the venture capital guys who really realized that it made the most sense for these two companies to become one, and then the whole kind of, eBay was another part of that. But I think about how, they weren't at the time worried about they were really just trying to find any market. But if you start to grow and think about how you're worried all the time about a cap or how big you're going to get, that seems very artificial to how you're trying to manage and grow a company forward. So I guess I'm curious, because I don't know that much about the merger and acquisition process. Do these caps on legislation seem like a good idea? Are they challenging where we're, how we're managing just capitalism in general?
So I'll start with an anecdote. Before any of the proposed bills were introduced, there was a hearing. It was called a legislative hearing, but there wasn't any legislation to consider. There was a hearing in the House Antitrust Subcommittee. This is probably 2020, something like that.
No one can tell time anymore. It's okay.
All the days are the same. And one of the things that I said to the members was the funny thing about the House majority's report on competition was that the front, 500 pages or whatever, were kind of an indictment of four companies, right? Amazon, Apple, Alphabet, which includes Google, and what was then Facebook, which is now Meta. And at the end, there were proposals. And the proposals were to change the antitrust laws writ large. And the thing I said to the members on the committee, we didn't have any legislative text to look at, was there's a mismatch here, right? Arguably, and there's a lot of argument to be had here, but arguably you have explained a case for certain conduct that four companies are involved in. But there are a lot of other companies out there in the economy, even if they don't dominate our day-to-day lives in the same way, even if we don't talk about them on Capitol Hill as much, your proposals over here don't track the problem that you've laid out over there. But the joke's on me, Shane. Why? Because the bills they ultimately came out with were sort of like, okay, yeah, we'll just do those companies. But this leads to another problem, and it's the following. My view of how to regulate generally, my view of how we set the rules of the road in the economy are that we try to figure out what's bad and stop the bad things. And there's a long history and a lot of doctrine that we don't need to get into today about how we do this in antitrust law. This remains an ongoing discussion in the courts for how we litigate antitrust cases. You want to stop what's bad, and if it's not bad, you want to let it happen. Now, there are times when things that companies do are worse because they're bigger, right? And so there are things in the law that we will condemn a monopolist doing where we wouldn't condemn a company that was part of just a very competitive market. But in general, I think if you want to stop people from doing something, you want to have a view as to why it's bad. That's not really where we are in the proposed legislation. We have some conduct, which I think people mostly agree is generally good, and I'll get to that in a moment. But we've decided that 5 companies shouldn't engage in that conduct without, in my view, a very coherent story of why those companies are especially bad or uniquely bad when they do those kinds of conduct. So there are a number of reasons this is problematic. The first reason is that the companies in question don't look a lot alike. They're all big and they're all tech, and so I guess we can say that they are big tech, although that term is broken in my view. But, Facebook's or Meta's business model is very different from Apple's. In fact, you see them fighting a lot in the market and in the press. They just don't do the same thing. And the same could be said of Google and Amazon, and Microsoft as well. So the companies have some similarities, right? They have some business overlaps. They have a lot of dissimilarities. And we've just picked these 4 kinds of conduct, there are a bunch of different bills. We've picked a few different kinds of conduct, usually associated with 1 or maybe 2 of them, and we've said you all can't do them. And that's a wonky way to regulate. The other problem is this. My view is you want to have a sense, and this is to your question, Shane, about what is the problem you're trying to solve, right? Like, what is the thing that you object to? And then you want to come up with some sort of scheme to stop that thing or regulate that thing. And then later we worry about, and I always worry about, unintended consequences. We're not even at step one. If you listen to what politicians are complaining about, they're often complaining about different things, and sometimes they're even complaining about the polar opposite thing. So I'll give an example. You will hear members on one side say, there is bad speech. We don't like the speech on this platform, so we need this solution. And then you will hear the politician on the other side say, the platforms are censoring speech. We have too little speech allowed on these platforms. Same solution. Those two can't be right. It can't be the case that if you want the opposite thing, the solution to both is the same. Like, that is like a matter of math. This is not logic. It's barely even reason. It's math that gets you where you need to go. I'm not saying I'm not being reasonable. I'm eminently reasonable. I just think there's like a lot of lack of clarity in terms of deciding what we want and deciding why something is bad and figuring out how to regulate. And we're in a better place when we think seriously about why is it that, this conduct is not okay if Amazon does it, but Target and Giant and Costco and on and on and on doing it is okay.
Oh, I'm completely there. I was commenting earlier that I actually get excited when I find a Kirkland golf ball, because I'll play with found golf balls. But it's like I was actually in the Safeway in Georgetown the other day, and this woman said, "Well, I got this on the sales rack," and the woman said, "That's not the sales rack. That's off the end cap." And that's the same idea of the self-preference. You're putting it in a space where more consumers are going to see it. Fine if you're in the Safeway, apparently. Not okay if you're one of these 5 companies, depending on what the item is. And so I find, and that goes to my challenge, and you said it better than I did, of like, what is it we're solving for? If we're saying that these 5 companies are causing challenges that no one can overcome, I just don't think that's right. And I think one of the great current examples is Shopify and ShopPay. That Amazon's one-click really was market changing. And I have to admit, I love the most amount of friction, or the least frictionless thing I can do on the internet is probably what I'm going to spend more time doing. And Shopify is finding a way to help bring the small and medium-sized companies into this space. They didn't need legislation to figure that out. They just needed to figure out some technology and then get consumers into their space. And they used the ability of the platforms to do that. So I just feel like stifling innovation at any level is the wrong way to go on that. So, but let's go a little more into the self-preferencing, because it is so interesting, because they're all different in what they're doing. And to me, what Amazon does the best actually is they're a logistics company. I mean, they do have certain items that they are saying that that you might want to prefer this versus that. If you haven't figured out yet that on the internet you can scroll down, I guess there's some things we need to learn about the internet, but. To me, it seems like the self-preferencing thing is an absolute. I don't know why they're so focused on it.
What's weird to me in terms of that focus is it's not conduct that is, in any respect, really novel. It's conduct that, in fact, is endemic in the economy. You see it everywhere you go. Literally, at the end of every aisle, when you go to the grocery store, you see this, right? You see it at Costco. That's not new at all. And the question is, how do we evaluate the conduct? Is it good? Is it bad? To me, that ought to be the question. There does it seems to me, some of the idea here is we don't like these companies, or some people don't like these companies, and so we'll stop them from doing some things, and they'll be less, and then the less what? Right? To me, I don't think we have a coherent answer to that question.
Yeah, and I guess I'm wondering if it was something that the FTC were to study, because I know one of the things that you've talked about in several of the pieces I've heard you discuss is that there was a time where the FTC was more of a think tank for the government. You would ask them questions, and they would think about it and bring back responses and bring more knowledge into the process. The fact that we're not putting somebody like Target into the same space where you're doing someone else, I don't know that if you weren't told ahead of time, go target the big tech companies, those are the responses you would come out with, that you would come out with this particular threshold. Or Walmart or anybody else who's out in that space. And especially as one of the things I love about summer is I spend more time out in America. I see a whole lot more Walmarts and Targets than I do in DC, but they seem to me like they should be included in this. They have quite almost as many shoppers when you put them all together. So actually online they're doing quite well, as well as the big guys. So would you pick this arbitrary number and say, here's your threshold, you now have a new margin you have to go towards?
I'll put it this way. We were talking about like numbers of users and market capitalization. It isn't clear to me, other than these are the companies we want to select, what the logic behind the threshold is, or behind the thresholds are.
So let's move on to another area of consumer welfare standard, because this has become a huge piece as well. And I'm going to start with, because I don't completely understand, the neo-Brandeisian. What is that? Because there's a lot of discussion about that these days.
So, it's not my argument, but I'll do my best to give my understanding of it. Neo-Brandeisian refers broadly to a group of people who are interested in reorienting what antitrust law is about. And I think if you were to ask them, I want to be fair here, what they would tell you is that the historical origin of antitrust law is either based entirely on or based substantially on the notion that the vision we have for the economy is one where big companies are bad and we need more rivalry. We need more different firms doing all the things, and that will be better both for traditional consumer concerns like price and quality and innovation, but also democracy and the well-being of labor. A lot of different arguments have been made about all the potential that antitrust law, properly oriented, can accomplish. So I think that's kind of the argument. Sometimes people reduce it to big is bad, and there's no question in my mind that the evocation of Justice Brandeis, or really Louis Brandeis before he was a justice, he was an advocate for sort of the small businessman and this kind of thing. How consonant that is with antitrust law, either the statute or how the law has evolved over the 132 years that we have had antitrust law, I think there too short shrift is given, and also on the implications of what this would mean. So to me, and this is easy because I work at the Federal Trade Commission and I know what our statute says, the law is about one thing above all, and that's competition. And competition isn't nice, and competition doesn't make sure that everybody has enough money to feed their family in terms of the people running the companies. It doesn't guarantee that the outcome is one of many small firms. Competition sometimes has winners. And so I think that to the extent the vision, and I think this absolutely is the vision, if you look at things like the president's executive order on competition from last July, the vision of a managed economy, the vision of the government having a much bigger say in what's okay and what isn't, of cutting the mighty down to size, that is a vision that isn't necessarily consistent with competition at all. And in fact, if you look at a lot of the proposals, like the president's executive order, they're not calling for more competition. They're calling for regulation after regulation after regulation, and assuming that the result of that is competition. And that is, at the very least, I would suggest, a counterintuitive interpretation of the word. So that's what the statute is about. Then there's the law, right? So one of the trends that we've seen, I think, in antitrust law over the last few decades, when what we call the consumer welfare standard sort of comes to be, is in a reevaluation by courts of a lot of rules, effectively court-administered regulations, that people had adopted because they assumed the kinds of conduct were bad. And what happened was, at a time of high inflation, like what we have today, people started looking carefully at the practices and saying, are these things necessarily bad? And what the research showed, what bore out in the cases as developed in front of the courts, was that it wasn't so clear that a lot of conduct that courts were condemning was in fact generally bad. And what we had to do was a more searching review, what we call the rule of reason. Now, who is the sort of classical expositor of the rule of reason? Well, it's Justice Brandeis. So there is a little bit of irony in the adoption of Justice Brandeis by the neo-Brandeisians. Brandeisians, something like that.
Data, I did go through the same thing, yeah.
Just as long as it's plural, please, can we come back to that?
We'll come back to that.
We'll see if I actually adhere to that. The final thing is this. The consumer welfare standard sort of comes to being out of a time where we have a widespread recognition that antitrust law is two things. The first is hampering American competitiveness. People are concerned that antitrust law is standing in the way of free enterprise and of America fighting with its rivals writ large, economically speaking. The second thing is a tremendous lack of clarity. So there's like this old joke in antitrust law that if you raise the prices, that's because you're a monopoly and you get away with extracting your monopoly rent. And if you lower the prices too much, that's predatory pricing. And if you keep the prices the same, that's collusion. That's like an oligopolistic market. And so businesses didn't have clarity on like what was in and what was out. And there was an attempt to sort of give some order to all of this. But critically also, I think, it comes at a time where we had really high inflation. And some of the negative effects of the regulation that we're now, not we, but some people are looking to bring back, in particular the President of the United States, what we saw is it was having negative effects. And maybe we were supporting some small businesses, I don't know, but we were definitely hurting people. People who have to feed their families, right? And people who have to do all the things we all need to do every day. It is some kind of irony that a mentality and a series of articles adopted at a time where we had like low interest rates, zero inflation, and critically in zero price markets, right? The focus is big tech, are now being proposed as solutions to our woes at a time where we have high interest rates and high inflation. This is the wrong time to be pushing higher prices.
So 2 points that have come out of the president's order to me were the non-delegation authority and having a better understanding of how we're trying to regulate the entire economy without a congressional mandate, it seems. And then the other one is case by case versus rulemaking authority. So if you'll help me with my FTC 101 this morning.
Sure.
This afternoon, sorry.
And forgive me, I'm about to bore all of you. So the Sherman Act, Congress passed the Sherman Act in 1890, and it's 2022. So that's 132 years of judges and litigants producing the law. We have, in effect, a kind of common law. We have some particular statutes. We've got the Robinson-Patman Act, tee off on that later. We've got the Hart-Scott-Rodino Act. We have the Seller-Kefauver amendments to the Clayton Act. But mostly, or in fact entirely, the law has been statutes the judges apply in litigation. The vision that the president articulates in his executive order is replacing that, or at least substituting that substantially, with rules that a majority of FTC commissioners make. And the scope of the rulemaking authority here is almost limitless. The evidence for that is twofold. First, the president's executive order has us making like device regulations and pharmaceutical regulations and labor regulations. Privacy, they want us to do a competition rule on privacy. I think there's 7 different instances. So it's not really clear at all what the president thinks the limit of our authority is. And one of the first things the Democrats did when they took over the FTC when Chair Khan was appointed was they got rid of the policy that we had on what the scope of Section 5, which is our statute under which, in theory, we would make the rules, is. So the first thing they did was take off any limits. And by the way, the limits were not much of anything to begin with. And in fact, when they were adopted on a bipartisan basis, in the Obama administration, they were criticized by then Commissioner Olhausen because they were too vague. Okay, so not really clear what the limits are. A novel thing that we're doing, right? We're making rules for the economy instead of how antitrust law has been done. One of the issues that raises to me, and it raises a number of different issues to me, is a legal one. I don't really think we have the authority if you look carefully at the statute. And I think the court that essentially created this out of whole cloth was pretty clearly wrong. That's a legal problem. In case it's not clear, I have a policy problem too, which is I'm not so convinced that my colleagues and I, no disrespect to them or to myself, would be good at running the entire economy. I don't think that we're built to do that. I don't think we've demonstrated our capacity to do that. But the third thing, and you alluded to it earlier when you talked about delegation, I think there's a constitutional problem here. If this authority is in fact so broad to answer all these questions, and the language is so vague, I think that it looks like Congress, and if it exists, which I don't believe it does, but if it does, it looks like Congress just giving wholesale legislative authority to an administrative agency. And that's a constitutional problem. That's a real problem in terms of how we orient our society and whose job it is to make the rules. Now, we've heard a lot, not on that particular doctrine, but from the court of late, on like when you're taking big chunks out of regulating the economy, how we're going to look at it. And I submit the signs don't point to yes, but I do think we need to have a really serious conversation before we accept the premise that basically a majority of federal trade commissioners can make almost any rule to regulate the economy that we want.
It's pretty wide. And, I mean, you guys are, I'm glad the Senate says yes to you, but you weren't elected to office. So I do think that'll be interesting to see.
No, we weren't elected.
Where that goes. So go through, so the rulemaking authority versus case by case. Just give us an example of where those different and why this is a challenge if you move from one to the other. Sounds like one's pure regulation and the other one's actually looking at
rulemaking is just another way to say regulation. So you're substituting a regime of looking carefully at the facts of a given case with a regime where we just make these broad rules and hope they work out. So again, I don't think it's supported in the law. I think it's unconstitutional, but also it's a bad idea. Because one of the benefits, to come back to Justice Brandeis, of looking at the facts of a particular case is that markets tend to be a lot more complex than political headlines. It's very easy to say self-preferencing, but how that looks as a practical matter in a given case is a lot more complex than just describing the thing as a general matter. And so, for example, even Congress, considering these bills, isn't willing to say that the conduct in front of them is always bad. They only think it's bad when a few companies do it. Now, I don't think they have a great basis to say that in the first instance, but even if you agree with that, I think one of the great things about antitrust law is that it cuts with the scalpel. And the trend in the development of the law over time has been toward the scalpel, away from the hammer. And I think that's a good thing.
So changing over to a case that I watch closely, because I've been working on privacy for over 20 years. And this is, I am a believer that privacy is an emotion, and unlike the Europeans. So I really think that what we can do is legislate and regulate around, now you're going to tell me if it's data or data protection.
On this one, I don't have a strong view. They've got to be plural.
Okay, because I'll say it in the same sentence. But so the whole idea of data protection, which really is, identity, theft is a huge issue that we're dealing with. Which is all these things have actual, there's criminal consequences. There are emotional consequences. But I think of what you can do is promulgate rules that will allow, like the Federal Trade Commission, to do things around data security or data privacy. And the Wyndham case was one I thought was really interesting because we were still trying to figure out our way there and doing a lot of cybersecurity work. A lot of times the companies were like, you didn't really tell us we had to do A and not B. And so they'll go to the lower threshold, not looking at the risk assessment. So we're changing that around. But I think the whole idea of, I think privacy is definitely coming down the pike, if not this year, soon. And the whole idea has been, many people wish it to go to the Federal Trade Commission. Are you guys ready for that, or to bring on? I know that you've had several people there in the past that have left recently, but the idea of becoming sort of if we call it the privacy czar, or the place that you go for privacy, and I'm just going to use that nomenclature because it's common. I still think it's data.
So I think we are, is the short answer to the question. We have lost some great people, but the FTC with the people that we do have that continue to work on privacy, my view is we're the best privacy enforcer in the world. So if you look at the outcome, and if you look at results, how do we do in cases? Do we go against the bad actors or the big actors when they are bad? What kind of remedies do we get? What kind of fines do we secure? Even without a national privacy law, the FTC is the clear leader. And I have had other enforcers from around the world call me, and they have privacy laws to enforce. They have massive penalties and say, how did you get that outcome? And I think that is a testament to the creativity, to the thoughtfulness of the people that we do have today. And I think if we're going to do a national privacy law, which I think we should, the FTC is absolutely the right place to put it. If we get a lot more enforcement authority, I think we will need more resources with which to do it. If you look at the size of like the ICO in the United Kingdom, they've got like 180 people, and the Irish, who, because of how the GDPR works, end up regulating privacy for a lot of the biggest companies. They've got over 100 people. Our DPIP, our division that handles most of this, it's like 45 people. So I do think, we're the United States, we're a bigger country. If we got more authority, we could definitely use more people. We could definitely use more people today. So I think we are definitely the place to do it.
So when I don't think we've necessarily had a wrong model. We just have more things that need control elements on it. HIPAA obviously is, I got a notice this past week that my doctor's office had been breached. I'm glad to know that they had to notice me. I'm not exactly sure what they plan on doing about that. Banking, obviously very important and a huge concern, for lots of reasons. But again, that's one I don't think of it so much as privacy as people need to understand how they secure their information. So if you got to help write the law that is hopefully coming forward, how would you delineate between the industry areas and then just consumers as a general area?
So first of all, it's not my job to write the law, and
okay, I know,
kind of
you
like
get
it that way.
Wishful thinking.
Actually, let's start with the areas, because
Okay.
I think you've just hit on something which is really important. One of the things that traditionally we think about a lot in the context of privacy is the relative sensitivity of different kinds of data, right? So your financial data is very sensitive. Your health data, I did it. I went singular. Your health data are very sensitive. And thinking about a scheme where we protect more those kinds of data, the disclosure of which, the breach of which, if it's not a legitimate disclosure, are more harmful, I think is critical. And on some level, this is how the law works today. So HIPAA is health information, right? And Gramm-Leach-Bliley is financial information, and COPPA is about information from kids. Maybe inherently the data is a little less sensitive, but I think we're all right to be a little more concerned when it comes to kids. That's a very reasonable place to be. That, I think, ought to be part of the discussion. And the reason I think it ought to be part of the discussion is one of the things I think we need to keep in mind when we're talking about any kind of regulation, but also privacy regulation, is harm. I think we want to be more interventionist in the economy where we have a reason to believe there's greater harm. In terms of the particulars, it's back to this issue of that I was raising with antitrust earlier. What are the problems we're trying to solve? So breach notification goes to this issue. If your data is somewhere you didn't expect, and in particular, singular, I did it again. If your data are in the hands of bad people, that can present a real risk to you of financial loss, of, kind of a feeling of creepiness, all of these things. And we, in certain contexts, are going to want people to know that this has happened. We want them to know about a breach. That's why a lot of states have data breach laws. Another issue I think Congress is thinking about, should be thinking about, is what we call, an information asymmetry. If you talk to a lot of people about privacy when it comes to consumer data, they tell you a story about, I don't know where my data are going. I don't know what's happening to them. And that has to do with, the solution to that problem is probably going to involve some mechanism for giving people more information or a better way to get the information they may want about what's happening to data gathered from them. The further out you go with privacy, I think you described it earlier as a kind of feeling, And one of the problems with privacy is sometimes we're not so clear about what interest we're protecting, what harm we're trying to avoid. The thing that gets me the most is you will sometimes hear, especially privacy enforcers, talk about like democracy. And it's very hard to tell what privacy regulation will get you the democracy you want. Among other things, because people have very different views about, what the right democracy will yield, but the connection between those two is far more attenuated. And so I think it's critical as Congress goes through this exercise that they get into the detail, right? That they look carefully, what are the problems we're trying to solve? People don't know what's going on, or people aren't informed when data are stolen. Those are real concerns, and I think those are the kinds of things that we can think about regulating, stopping, so forth.
I'm a big believer in transparency and accountability. So if I got to help write or draft the legislation, those are the two things. I think you need to be very clear about what information you're gathering, and you need to be accountable to what happens to the information. And hopefully there's an audit function on that too. So if you didn't do what you said you were going to do, there's maybe a punishment mechanism. I also think there should be emojis. So I know which one you're not getting. Like if there's like 5 and you go, this one's missing, I won't go there.
So I remember reading when I was in college, probably not the paper itself, but about some paper that was talking about all of the communication that babies do kind of before language, and how humankind, like other animals, we do a lot of our communication without language. Now, we're unique, as far as I know, in having language, so we have this additional means of communication, but you can convey a lot without words, and emojis are kind of an example of that. If you've ever had the horrible experience of watching 9-year-olds text each other, there's a lot of emojis going on. It's a horrible experience. I think I left something out which is really important, which you alluded to as well, when it comes to privacy. A lot of people, when they're talking about privacy, and certainly when they're talking about data protection, are talking about data security. And that is an area where I have certainly become convinced we have a kind of market failure. We don't invest enough in protecting, and we have a real harm, like a real series of threats from state actors, from criminals, and so on. That's definitely an area where I think we could do rulemaking. I would love to see legislation from Congress, an area where we, I think, societally need to move in a direction of greater protection.
Your former boss, Senator Cornyn, during a hearing on the legislation we've been talking about, said, I think it's important for us to affirmatively state that providing access, and he's talking about interoperability, would expose consumers to malware or other cyber attacks or theft of their personal information. It should not be allowed under this bill. And it's one of those things, I feel like I've had these nonsensical conversations with my friends and colleagues I really like up in the Senate, but the interoperability is a real challenge. And there was a Lawfare piece a couple weeks ago explaining if I'm on, I'm an Apple user, so I'm on iMessage, and then you want to talk to me now on something else called, I don't know, foot and mouth came to mind. I don't know why. Just like, something. But it's like, I have no idea. But now, because you want to go there, this is actually more of the European law, but we're looking at emulations of this. All of my information and our data is going to get transferred to this new app, and I would have the ability to just say no and not talk to you anymore. Or all this information goes to somebody, and I don't know what their third party operations are on this. And so the interoperability really needs to be thought through at a much higher level. And then also to the national security point, the national security gentlemen and women keep pointing out that this is a real concern. And I don't know why those are just red flags dropping everywhere. We're just ignoring it. I don't quite understand why this is the way that especially when everybody's got some device like this they're walking around with vast amounts of information on it.
When you're in the federal government and you travel abroad, they wipe your phone, they make you take a new phone, right? Security and the ability of people to get around security is a real thing. What I think, so I worked for Senator Cornyn for 7 years, and long before he was a senator, he was a judge for many, many years, both on the Bexar County Court in San Antonio and later on the Texas Supreme Court. And one of the things that judges do, and that if you ever spend any time with Senator Cornyn, you realize he does all the time, is like they look at two sides of things. When it comes to fashioning policy, I think we are compelled to recognize that there are no free lunches and that there are trade-offs. And that's true for competition policy, and it's true for other kinds of policy. Sometimes it's easier to grasp what the trade-off is. You're protected from this environmental harm, but there's a cost, right? And implementing the mechanisms for mediating that harm or for reducing that harm or eliminating it entirely comes at some sort of cost, and we can do an easier cost-benefit analysis. The more complex the environment, maybe the harder it is to do the weighing. But I think that for people who insist that if we just write a bill, maybe even if we write words, don't worry, this doesn't apply to your concern about privacy, security, speech, one way or the other, people are at different ends. We don't care, or we can just write around it. I think that is giving far too short shrift to how complex technology is, how complex the operation of markets is, and there is no free lunch. All of these policies come with real trade-offs. The failure to grapple with them, I think, is part of the reason that we don't often make the progress a lot of people want.
And the other element of that is another potential national security issue is China, basically. That now we're saying that the things that we will hold these 5 companies we were talking about earlier to, we're not going to hold most other companies to them. There may be others, but the biggest challenges we have there are China, and we know that anything that goes on a Chinese server, the Chinese government can knock on their door and say, hey, we'd like to see what you've got going on there, and they have to share it. And as we've got people on different apps that are sharing information across boundaries, this continues to be a concern of my not knowing where that goes. So again, it goes back to my transparency and accountability. I think Apple did a pretty good job with I always get AT&T app tracking transparency done well, in that the first time you opened an app after that they changed their operating system, it was just really surprising to see all the information that was getting gathered on you. I mean, sometimes I was like, it's Uber, it needs to know my location. Like, I'm good on that. Other times I'd look at the app and be like, why do you need my contacts? And there's sometimes I don't like the idea that I'm losing the ability to use the app because I'm saying no to that. But there's, at least now I'm aware of the fact that it was sucking all this information off and wandering off, to somewhere else. And actually that's another piece that the Lawfare article, which I'll try to track down, was saying that it's really potentially creating a Cambridge Analytica situation again by litigation. By legislation, by saying you have to now share this information, which is what got us in trouble in the first place, is not understanding where all that information was leaking off to in Facebook when people were running around doing quizzes. So when we settled the Facebook matter, that sort of came out of the Cambridge Analytica thing, Alex Stamos quipped on Twitter that we needed to pick a direction, because what we did in that settlement, and we did a lot of things, but one of the things that we did is we made it a lot harder for Facebook to share data with third parties, because that was the thing we were dinging them for. And to Stamos, who is a data security guy, he was recognizing that there was an inherent competition trade-off. Those data were relevant to businesses. They were going to use them. You mentioned tracking transparency. I think this is maybe one of the most interesting things going on in tech policy today, because, Apple's got a really easy to use screen, and we see it and it pops up, and they require you to, what do they call it? Nutrition labeling, right? There's a certain set of categories of how we deal with your data, and maybe that's a really good way. I mean, to me, it seems like a good way of conveying to people the complex question of how are these data being used? But, not that I care particularly, but Meta's stock price cratered by hundreds of billions of dollars. You've seen all sorts of complaints from people who use the data from tracking to help reach customers, right? That's what targeting advertising is all about. Ben Thompson writes about this. And so I think the point is not that one is right or the other is wrong, but all of these things come with trade-offs. And that's just a critical thing, especially in tech policy, everywhere in general, but especially in tech policy, that I want putative regulators, that I want legislators, that I want the public to keep in mind. Yeah, I've been doing this for quite some time, so it always surprises me how little people actually understand about the differences on the platforms. And what was interesting, I love Ben Thompson, a huge listener and reader, is that while Facebook was losing because they were not able to give the vision in to their system. As they say, they don't sell their data. They invite you onto their platform to share, their users, and you choose.
And monetize it.
Yes, right. But Amazon was sort of winning in that process because they keep all theirs in their closed environment as well. And they actually advertise because they know the information of what you had. But to the general population, that's a kind of a difference without a difference. They're like, I don't know, someone's got my information and they know more about me than I thought they did. And so the idea of, again, transparency and accountability, just letting me, again, how much of this am I able to manage? And you actually can, as a consumer, manage quite a bit of it. You just have to take some time to go through many menus. And every once in a while, I just do it just because I want to see how hard it is to do it. Or Wired writes an article, and I'm like, okay, I'm going to go, and then I wipe out all my cookies, and then I'm like, why? Why did I think that was a good idea? Makes my life much more miserable. Okay, we are at 2:15. We promised we would go to some questions, so apologies, I'm going to read these out loud. We're going to see how they go. Question number 1. Moderna announced a while back that it would not enforce its patent claim against generic manufacturers having any situation. Yeah, is this the wrong? I was going to say this. Are you guys going to send me a new one? Scroll to the bottom. Okay, I was like, isn't this the IP
Shane,
one that we did a couple weeks ago?
That people know to scroll to the bottom.
All right. Okay. Yeah. Well, by the way, that's a really interesting case we wrote about it last week. Okay. Am I starting with from InfoSec? Yes. Okay. Yeah. This is the tech team, by the way, here at AEI. It's going great. For the InfoSec organizations to support a right to repair, there are many examples of companies with dominant market positions, like John Deere, using hardware linked to software and services to lock out competition, the service to repair. So this is I'm going to forget something, Magnuson.
The Magnuson-Moss Act.
Okay, that's what they're asking about. And they want to
Warranty,
know
blah,
the
blah, blah.
FTC prepared to do about this behavior. So, and I think about it because I walked by 2 YouFixit places on the way over here. And so if I understand this, because I'm going to stick to, John Deere's important because we need tractors, we all need food. But so let's say I have this device and I break the screen on it, but if I take it to this one happens to be Apple, it could be Samsung, it could be anybody else. If I take it to someone and they are not authorized and it's under warranty, that's where the problem is. Is that what people are concerned about? If I put glass on this and it isn't the one that goes to the warranty, and then they do something to damage the item, I've now made the warranty null and void. Is
Okay,
how I'm understanding this? Okay.
What the law says is that you can't condition your warranty on someone using your branded stuff. I'm simplifying a little bit, but just bear with me for a moment. So if you are Harley Davidson, you can't write into your warranty that if you use non-Harley Davidson parts to fix your motorcycle, you're no longer under warranty. That's what the law says. And I'm picking on Harley Davidson because we just did a case involving Harley Davidson where we made them change this aspect.
Wouldn't it be
warranty.
sacrilege to have a Harley Davidson that's not just Harley Davidson parts? I mean, isn't that
People
part of the
fix their
coolness?
bikes all the time.
And they use other stuff?
Sure.
Oh, okay.
So the law is a little bit more complex than that, but I do think it's a statute that's been on the books since the 70s. I think it's really important. The FTC has gotten a lot of press of late for some things that are sometimes divisive. But one of the things I love about the agency is we've had a really good tradition over a long period of time of a lot of consensus things. And so we had a report on right to repair that we issued to Congress under Acting Chair Slaughter. That was a unanimous thing. And then we adopted a policy statement, consistent, by the way, with one of the better parts of the president's executive order, that we were going to look into right to repair. That was also a consensus document. And one of the aspects to this is looking at whether limitations that companies place on repair might be anti-competitive. You're right to note, a lot of those limitations are going to have a really good reason. So not every limitation is going to be illegal or even bad. But the law itself, the Magnuson-Moss Act, does prevent certain conduct that I think is a deterrent to people getting, let's call it more competitive, but cheaper, more accessible access to repairing devices or tractors or what have you. And I do think we are right to be enforcing that law.
So is that specific to hardware? Because so much of what we do now is software updates. Like I'm almost seeing like your Tesla car. So the car itself is not changing as much as the performance is enhanced because there's a firmware or a software update. Is that covered by it or no?
So I believe it is. I hope I didn't get that wrong. I don't think it's specific to hardware or software. What I will say is, I'll say two things. The first is that everyone should update, when you get
Always.
the patch. Always. This is like very important for data security. The second, that's like public service announcement. The second thing is, I do think as the devices that we have become more complex, the trade-offs are a little bit harder. It's easier on the one hand for companies to mask just limitations of competition behind excuses. Well, this is complex. But also, right, the ability to introduce something like malware, if you just go to some random shop, might be greater. And that's a tension that I think we grapple with. That said, I do think we are right to continue to make sure that where people are imposing restrictions on repairing devices, that they're doing it consonant with law, and that for purposes of antitrust law, there's a real justification.
Yeah, that's very interesting. My first car actually was an MG Midget, and the guy who ran Shop back when people used to
That was
shop.
your first car?
I know, it was a great car. It was about this big too. So they were like, you could open it and you could see everything in the engine. It was really fun because you could figure out what it all was. And now I couldn't touch my car for my life. Like they don't even let you look at it. They're like, they cover it so you don't mess with it unless you know what you're doing.
So yes, but this is in part like as I became a homeowner, more of a car owner and had kids, public service and all that. YouTube has a lot of great videos on how to fix things.
You can, I do that. A friend of mine we were just looking at this new device and I was like, I've got to go, but you should just go get on YouTube, just say what model oven that is and it'll fix, there'll be something on there for it. It's amazing.
I use it, among other things. It's a really good way to suss out very quickly, is this the kind of thing where I want to go to the shop or not?
Right, exactly.
Switch your air filter, fine. The clanking noise in the back, no.
Yeah, exactly.
I'm not going to do that.
Okay, so another question here. See, some have pointed out towards the recent baby formula shortage as a smoking gun that lack of competition is detrimental to the American economy and consumer. Is this even accurate as to how you would counter this argument? I know it was a big deal, and I wasn't paying that much attention to the baby formula situation, but
let me say the following. There is nary a problem that I have seen in the last, my tenure is a little bit more than 4 years at this point, where someone hasn't pointed to it as stemming from a lack of competition. There are markets that are going to trend toward greater concentration. There are other markets less so. I'm not persuaded that every problem we face in society is traceable to either a lack of competition more generally or some failure of antitrust enforcers. This is compelling rhetoric for some. I just don't think it's borne out by the facts.
But now I want to make up a game that's just like, you just kind of go through and like, is it one or the other? And then you can come up like the other and there's a bunch of things.
Can I give an example of this?
Yes.
So one thing that's really hot right now in antitrust chatterbox world is like labor antitrust. And we're looking at mergers for labor effects. And I think that's good because I do worry that sometimes you're eliminating competition for labor. If you've ever been to a Chinese restaurant in New York City, or rather ever looked for a Chinese restaurant in New York City, you would know that there are a lot of them. It's essentially as close, I think, as we could come to perfect competition. There are labor problems at Chinese restaurants in New York City.
Wow.
Like, it's not just competition is going to solve every problem. And the funniest thing is that a lot of the people pushing these narratives are really interested in regulating a lot. Like, they, on the one hand, have what sounds like a kind of Randian libertarian approach to the world. If we just had competition, all the problems would be solved. But then when you ask them, how do we get competition? Like, the government's going to control this and the government's going to control that. And there's a lot of, I think, it's like cheap talk. When you peel it back a little, it doesn't make a lot of sense, at least to me.
Do you have any questions in the audience? Back here, Will.
Try to be brief because
And can you
brought
introduce
up so
yourself,
much.
please?
J.P. Hogan, right, a citizen Rosebud. But you're bringing up the general welfare versus trust. The big five would be an issue has there become a secular authoritarian matrix determining a political correctness versus people having the right to be in God we trust. So where do you cross the religious freedom line as far as if someone's creating a message and saying and interrupting the message from having the truth be in there? Where are you allowed to use the language for religious freedom in antitrust?
I mean, I think the short answer is nowhere. I don't think that what we're doing is protecting religious freedom. The Constitution protects religious freedom. Some
But
of
if
our
you're
statutes,
allowing an authoritarian message to override and supersede where the people want that freedom, you've crossed a line that something has to be said.
So again, I think what we're doing is we're protecting competition and consumers. Religious freedom is incredibly important. That's why it's protected in the Bill of Rights. That's why we have statutes like the Religious Freedom Restoration Act. I do think it's very hard to see how that fits within the framework of competition law.
Other questions here in the audience, over in the corner?
Hi, Amy Boss with NetChoice. What do you fear most about the next 2 years under Lena Khan, and how do you see the Supreme Court's recent EPA ruling affecting her plans?
So let me start with the second question. I think the Supreme Court's recent ruling has to do with what is in effect a rule of construction, the major questions doctrine, how the courts are going to evaluate rules that make a major impact on our economic, on our social, on our civic life. And I think the agency, Chair Khan has articulated, and others around her have articulated, a very ambitious regulatory program. And I think what West Virginia versus EPA, but also many cases that came before it, and recent cases too, cases involving the vaccine mandate, the eviction moratorium. What they counsel above all is, I think, a level of real fealty to the congressional command, real care in what we have authority to do and what we don't, and real humility in where we claim broad authority, trying to do it as a matter of regulation as opposed to case-by-case enforcement. In terms of what I fear, there's sort of institutional concerns, which I'll leave aside. Above all, I want us to be doing our job of protecting competition, which helps consumers. And I think that we are throwing up into the air, and this isn't the chair specifically, a lot of antitrust reformers are throwing up into the air a lot of promises about what antitrust should be, or is, or can be, and their ability to catch those balls thrown up into the air, I think, is a lot less than they're pretending. It's very easy to say some of these things. It's a lot harder, in fact, to do them. And I think that the two biggest fears that flow from that are, first, even if I don't agree with the goals, we may not achieve them, and that creates a kind of credibility problem. And the second thing is, I do think, to the trade-offs I was talking about earlier, the costs of overregulation and the costs of enforcing, in particular where the law does not apply, and we have statutes and laws that tell us where the law does not apply, will be innovation, and will be low prices, and will be competition over quality, a lot of the things that everyone purports to value. And I don't want to lose that, and I don't want to lose sight of that.
Questions on this side of the room?
Thank you. Nicholas Plansky, British Embassy. I was wondering whether you have any thoughts on whether the FTC will do anything about AI and online harms. I know that there have been a lot of reports published by Commissioner Slaughter and also recently by the FTC and the reports into Congress. You've opened a period for public comment about it. So I was wondering whether you had any thoughts on it and whether it even falls within the FTC's purview.
Oh, I have lots of thoughts, and I wrote them in an accompanying statement. Congress charged us with preparing a report on how effective AI was in combating certain online harms. And the report we came out with, the process in which we engaged to get to the answers at which we arrived, I don't think was a good process for answering that question. Among other things, we didn't talk to anyone using AI to try to solve these problems. What we did was we read some news articles and we read some academic pieces. I quote one of them in my statement, which is like not even comprehensible English. we read a lot of people who had a lot of nasty things to say about the role of AI in society. Now, to be clear, I think AI raises a lot of really important questions. And I think those questions ought to be debated. I think we ought to look at news reporting. I think we ought to look at what scholars say. But I think that we ought to do a real examination. That's thing number one. Thing number two is this. AI is a series of tools, effectively. And I don't see us banning AI. I don't think anyone's going to ban AI. Like most technologies that generally produce good things, in fact, one of the most amusing things about a report is one of the things we cite for how bad AI is academic work or like kind of corporate analytical work done using AI. The question is how to live with it, whether to regulate it, and if so, how to regulate it. Those are the important, serious questions that we need to be asking. And I mean, again, you can read my accompanying statement. I did not feel like we did a good job on that one. I do think AI raises all sorts of issues. But I think if we're going to grapple with those issues, we need to do it in a sober way. And I just felt like we didn't quite live up to that.
Oh, we got one last question right there.
Hi, my name is Andy Zell from Capitol Hill. Want to bring the conversation to healthcare and wondering what your thoughts on how do you assess the performance of the consumer welfare standard in light of kind of healthcare costs and skyrocketing drug prices and hospital bills, et cetera.
So I actually think if you look over the history, healthcare is one of the areas where we have been incredibly effective, right? So we were losing hospital cases in the 90s and early aughts, left and right, and now we win them. There's one exception to that, but over my tenure, we've won all but one of the hospital cases. I think hospital mergers present a lot of real serious issues, and so I'm glad we're on that. I think also in pharmaceuticals, if you look at what we did with pay-for-delay settlements, going back to the activist case in front of the Supreme Court, and then more recently, even in the Fifth Circuit on the impacts case. Healthcare markets are, well, to some extent, they're barely markets, right? And you've got all sorts of regulatory overlay. You've got all sorts of competition problems. The consumer isn't negotiating with the provider on price, right? It's all mediated through insurance. So one of the things we have to look at is what's the competitive dynamic, including the insurers. And often our best witnesses in these hospital cases, by the way, are the insurance companies. One of the things I really worry about with some of the neo-Brandeisian ideas is they have a very leveling the playing field between small and big. And that's kind of a nice story to tell in certain markets, but think about it in the context of healthcare. A bunch of doctors get together to negotiate against the big, scary insurance company. That's the big corporation. They have all the money. They're very scary. We do not want doctor cartels. This is a bad idea. It will raise prices. It will reduce choice for consumers. Is everything perfect in healthcare markets? Not at all, right? If you look over time at trends in America, like what Americans spend on things and what things cost, education, housing, and healthcare, the trend lines are upward. Consumer products, electronics, they go downward. Same consumer welfare standard, but the big difference is, I think, right, healthcare is, you have IP protection and how we manage patents is a real issue. There's a lot of issues about regulation. I think it's a much more complicated story than consumer welfare. But to your point, I think this is one of the areas where we have brought our most interesting cases, where we've got a great record, and where I hope we continue to do that.
Great. Commissioner, thank you so much for your time. Thanks for all the work you've done up to date and all the things that I know you plan on doing. Kind of a last thing, I know you mentioned you may get to take some time off in August. Anything you recommend that we read going into this fall, getting ready for all the fun that's going on?
The best thing I have read recently is Greg Worden, who is he's not an attorney actually, economist at the Department of Justice's Antitrust Division, has a book called Foundations of Antitrust, which to my mind it's so informative, it's so well written, it's so readable. Right? A lot of the stuff I do is not particularly readable, but I think his book is terrific. It's Foundations of Antitrust. That has a picture of Sherman, not the one who burned the South, but his brother wrote the law.
We'll take a look for it.
But thank you, Shane, so much for having me.
Absolutely.
This was a real pleasure.
All right, thank you very much.